Welcome, everyone. I'm Lisa Escobar-Long, editor of KPC Media's Greater Fort Wayne Business Weekly, and I'll be your moderator for today's webinar. This is the fifth in a new monthly series that we're bringing free to subscribers. The topic of today's webinar is data privacy, challenges and recommended practices in a changing landscape, with a presentation by Barrett McNagney. We want to hear what you're concerned about. So during today's webinar, please ask your questions by going to the Q&A section, not the chat, but the Q&A section that you'll find on the right-hand side of your screen. We'll go over your questions periodically throughout the presentation, and then we'll also go through them at the end as well. Here with us today is Justin T. Molitoris of Barrett McNagney. Welcome, Justin. Please tell us a little bit about your background and start us off on this important topic.
Great, will do. Hey, thanks, Lisa. Good morning, everyone. Thanks for joining us here remotely and digitally, and we'll go through this presentation, as Lisa said, titled Data Privacy, Challenges and Recommended Practices in a Changing Landscape. One moment here while we pull it up. So a little bit about myself. I am a business attorney here at Barrett McNagney. I do strictly business law. My practice is primarily mergers and acquisitions. So the buying and selling of businesses takes up about 60 to 70% of my practice in a given year. The other major and most significant portion of my practice is data privacy and cybersecurity. To that end, I have a certification from the International Association of Privacy Professionals for a certified information privacy professional in the US. Other certifications, mine is strictly focused on the United States. But again, my practice is to counsel businesses from start to finish, formation, structuring, general business counseling, compliance, specifically in the data privacy realm, and eventually sale or purchase of other businesses. So we're seeing data privacy growing every single year, almost on a monthly basis, it feels like. It's a growing concept as a whole, and there's a number of reasons for that. First, the standard disclaimer, this presentation is not legal advice, does not create a attorney-client relationship through your participation. Keep in mind, each and every individual or business's circumstances are different. And so a general presentation can't really satisfy all your legal needs. So reach out to a professional and go from there. Why are we concerned with data privacy? Before we get to the slide, a couple big issues and new concepts are the growth of data over the past 20 years. An interesting statistic, which blows my mind every year, is that I think in 2015, the year 2015, that single year, the human race doubled the amount of recorded data it had from the entire prior history. So in 1 year, we doubled the entire amount of data that we created. What happens to that data? That's the biggest question, right? How do we treat it? What's the exposure? And that's where data privacy comes in. But the other aspect is, how are we creating that data? You know, why is there such a growth in an explosion in data? Why is there big data, a whole industry devoted to the collection and algorithms related to data and the monetization of data? Well, one reason of that is this concept called the Internet of Things. So 20 years ago, our access to the internet was sitting at a computer, hitting the dial-up modem, waiting for connection, pulling up your browser, and that was the internet. And that's all we had. That's not the case any longer. You know, if I think about my household alone, we probably have 10 or so pieces of technology that can access the internet and access the internet almost continually. You know, 2 iPhones, a smartwatch, 2 iPads, smart TVs, a robot vacuum, right? We don't have an Alexa, but something like that is always connected to the internet. And all of these devices are always creating more information. More information creates more data creates more liability or exposure, or more opportunities for monetization. But from a business perspective, we're also increasing the number of Internet of Things items that we have. You know, we have laptops, our email is attached to our smartphones, iPads, different types of software. All these things are creating more data, which is what we need to protect. Now, why we are concerned today is one of the reasons is we're seeing more headlines. There's more reports of data privacy issues, whether it's hacks, unauthorized disclosures. So the SolarWinds hack from about 8 months ago was considered at the time the biggest cyber attack in history. And this wasn't a single bad actor who came in and has that black hat on and is hacking into the network. It was someone who installed, or a state actor who installed malware on a computer that sat there for 6 to 8 months before it was activated. Just sat there with an open back door for hackers to come in if they needed to lock out systems, all those things. So we're seeing headlines all the time. And just this week, there was a Bitcoin hack where a multi-factor authentication, so a login procedure failed, and it led to, as you can see, the stealing of the cryptocurrency from 6,000 accounts, which has real monetary concerns to consumers. Other issues of concern are we have more vulnerabilities with more devices. There's more access points. There's more vulnerabilities. We have employees who have more devices, creating more access points, creating more weaknesses. And then the barriers to entry for bad actors are just so much lower sometimes than the cost it takes to protect against them, that we're receiving countless attacks and having to protect against all of them. Remote work added its own interesting twist to this. Last year, about in March, everyone went remote, and all of a sudden we're not in the secure brick and mortar building where we know where our networks are, we know where our access points are. Instead, the workforce is working from their own networks in their own environments with whether or not they're service providers in the home or other employees. It's just a different sort of circumstance. And then phishing. And we'll touch on phishing in a little bit more detail. But phishing are these email attacks that I'm sure everyone who's participating today receives. Someone has emailed you about a business opportunity or says they have these files on hold for your review. And this is one of the ways that hackers gain access to a system. Other reasons we're concerned are enforcement itself is growing. And we'll touch on it a little bit later, as the laws related to data privacy mature and get a little more widespread, there's more regulatory authority, there's more oversight, and it leads to more enforcement. So historically, in the United States, the FTC, the Federal Trade Commission, has been primarily responsible for enforcement of cybersecurity-esque items. I say S just because we don't have a federal comprehensive cybersecurity law or data privacy law. And so they have had to be a little creative in some of their avenues for enforcement, but that's changing possibly. States attorneys general as well have had enforcement and oversight responsibility. And the last reason why we're so concerned is our own operational integrity and goodwill. So hacks, as we say, create headlines, right? And then the public knows about it. And how does that impact our day-to-day operations? How does that impact the way our customers view us, how consumers view us? And also, from another standpoint, how does that impact our own data? Each business has its own confidential information that it needs to protect. And to do so, it needs to ensure that its cybersecurity practices are adequate, right? So by having a stringent cybersecurity regime, we're able to protect our own confidentiality and our own goodwill, and hopefully help the business succeed moving forward. So that brings us to the question of what data needs to be protected. And we talked about our own confidential information a little bit, but from a regulatory and legal standpoint, the data that needs to be protected is the personal information of consumers. That's the most sensitive data that the lawmakers are worried about. So then the question is, what is personal information? And there is certainly no one definition, no one universal definition for that. Is it personally identifiable information, confidential information, private information, sensitive information? With a resounding yes. I mean, it's all of those things, but it also depends upon which legal framework you're falling under. So sensitive information, personal identifiable health information for HIPAA purposes is certainly different than personal information for a California state law perspective. And so there's just different definitions that we need to satisfy. So we need to satisfy that highest bar, and we need to find out what that is. And lastly, is personal information defined by inclusion or exclusion? So there's different ways of drafting these definitions of personal information. I'll put a couple up for you here. But some is, hey, let's throw out the net, capture everything, and say you need to protect that except for these certain things. And then the other definitions as well, no, personal information is this, but not that. Again, different ways of drafting. So here are two definitions of personal information. From the Indiana perspective, so to start out, Indiana does not have a comprehensive data privacy law. All right, we do not have a law that provides the same sort of rights that other jurisdictions do, like the definition below, which is from California's California Consumer Protection Act, which is a very, it's a comprehensive privacy law to the extreme. It is the highest bar in the land right now. But Indiana's definition of personal information means an identifier, so social security number, individual's first and last name, and one of the following. So driver's license number, state ID number, credit card number, financial account number with access information. So I look at it from this perspective that Indiana's personal information definition is identifier plus. You need more, and there's a reason for that, and we can touch on it a little bit later. But Indiana's definition of personal information also expressly excludes encrypted information or redacted anonymized information. So personal information is not any of these things if it's encrypted on your system, and that encryption is not faulted in any manner. Now let's pair that with California's definition of personal information, which means information that identifies, relates to, describes, or is reasonably capable of being associated with, or could be reasonably linked directly or indirectly with a particular consumer or household, right? This is the broadest net that you could probably cast out there. So it's something that could be reasonably linked directly or indirectly. The issue with that definition is it's a moving target, right? If you look above at Indiana, we have these set things, identifier plus these specific things. But the linking of information to individuals, or interestingly with California, or households, it's always changing. And that's because we're always developing our technologies. So before, again, 20 years ago, if you were working under Indiana's definition, you still knew what personal information was. But 20 years ago in California, linking ISP, an internet service provider addressed to a household, was strictly related to that one computer that was in that household. Now we can identify information that could be reasonably linked indirectly to a household based on a smartwatch or a cell phone, or all these other different things. And so that world of protection that California has created is it's a lot broader than Indiana. And that's why the bar of protections under California law, one of the reasons why it's a little bit higher, or significantly higher, I should say. Now, the next aspect of data privacy is, the breach side of things. So we know what information we need to protect, the data that we're concerned about. But then what is a data breach? What is an issue with that type of data? And it's not just the hacker who's sitting behind a screen who hacks into your system and grabs information. It's more broad than that. And it's the unauthorized access, disclosure, or use of personal information. That's the general concept. Under Indiana's law, it means the unauthorized acquisition of computerized data that compromises the security of personal information maintained by a person. So, yes, it's the unauthorized access, but there's also a compromised piece to it. Now, generally, if someone has unauthorized access, it's easy to make the case that they've compromised the security, but this also ties in to the concept of encryption and anonymization. So if someone has breached your system and has accessed encrypted data, but they can't, turn it into personal information, they can't attach it to an individual, then there really isn't a breach, and there's not much concern there other than, hey, we need to shore up our systems. But there are so many other different types of breaches and causes of breaches. So again, we talked about the hacker, that person who attacks your system with a computer code, and they come in and they get into your network and your servers, and they lock everything down. But that's not the only breach that the legal frameworks are concerned with. So some things that people might not contemplate is asset loss. So again, we're talking about all these different types of data assets, of technology, the laptop, the iPad, all these things that have access into your system. Well, if somebody loses a laptop, an employer's laptop or a laptop that just has your information on it, and a third party is able to access that system in a meaningful manner, well, that's a data breach, right? If they have access to your information from your asset that's just been lost or stolen, that's a breach. And then these other ones, if we go to the bottom one, unauthorized use, similarly, you can have a breach internally. If we have an employee, disgruntled employee, ex-employee, someone who had been granted access to certain information, but has no longer authorized to access that information, but does, that's a breach, right? We're using information in a manner that we weren't supposed to, and beyond the scope of which it was disclosed. And so that would likely fall under our data breach laws. Now, the middle three there, I should say, malware, credential stuffing, phishing. These are all the types of data breaches that we probably think about on a day-to-day basis. Again, I'm sure we have all received the phishing emails, and we'll just look at a couple here shortly of how bad actors reach out to you or your employees to receive business information and to be able to use it to access your system. I'll say this throughout, but one of the humans are humans, right? And so our employees who are humans are a weak point. They will make decisions not in bad faith or in any manner like that, but a decision itself that weakens our system. So the more we can educate our employee base on the threats out there, the more they understand that and the buy-in they have into, hey, I'm the first line of defense, the more likely we are to have a secure cybersecurity framework. So let's just look at a couple examples here of phishing. So these are real emails that attorneys at Barrett McNagny received, this year, as recently as Sunday, October 10th, it seems. So here's an email that says, I would like to get your legal representation for a purchase and sale agreement. Now, I did not receive this email, but as I said earlier, that's the type of work I do on a daily basis. And just like you, we're always trying to grow our business, right? And so you just read through the email and, for more information, kindly revert to me via email below, misspelling there. I await your responses. If not a business attorney or unavailable at the moment, would you please be kind enough to refer one to me? So, it's more than just the one sentence. It's asking for additional help. It looks like a company. But then if we go up to the address line here where it says from, and it's the construction company's name, but if we look at that email address, well, that certainly doesn't coincide with the name of the company, right? So there's one indication that, this isn't a legitimate email. This could have been this Michael Pearson, if we assume that 1964 might have been a birth date, might have been someone who was, subject to their own hack back in the day. Someone gained access to their email system. Now they're sending out mass emails to use their email address as their staging point. And so that's one suggestion that this is a phishing email. Other ones, the email in the signature block does not match the email on the address line. And then one unique one, which I have found in, a vast majority of the phishing emails I receive, is the use of the word kindly, because I get that in every single phishing email. Kindly revert to me via email below. And I will say I work with a lot of polite individuals, but kindly in the body of the email is just not a common occurrence, but it shows up in a lot of phishing emails. And then here's another one from last month. And if we look at the address line here, it comes from itbarrettlaw.com, or at least purports to, and we see that does not match up with the actual email address there. But again, some employees might see itbarrettlaw.com and assume this is an official email from my employer. I need to pay attention to it. And then if we look at the body, it purports to be from Office 365, and it purports to have documents that we need to view for our business, right? And so the concept here is they would like us to click on the links, preview the facts. There's probably another window that would allow us to put in our Barrett login information. And so what the bad actor here is doing is they're trying to get legitimate credentials to access our system. And so if you click that link and it showed up that, hey, put in your login, put in your password, and then you submit it, well, now this person has a legitimate login to our system, and they could use it to exploit that, to log in remotely and access our servers, and whether it's place malware or whatever it is, or to lock down our system or ransomware, they could do that with legitimate credentials, which could come just from an employee clicking on an official looking email. Just backing up real quick, this email, what they're looking for here is a response, right? They want someone to reply to the email to show that there's a live body there, and then they'll probably follow up with additional emails to try to get to the login information that we suggested would come here. Other aspects of hacking, similar to this, is credential stuffing, where there'll be a bad actor and they'll just start throwing login information and passwords at a screen and try to get the one that works. That's why strong passwords are very important. Changing passwords often are very important. If you have anybody in your enterprise who uses the password, that's a big issue. A common password, which I didn't realize until this year, is people will change their passwords to match the season and year. So I read an article about, I think it was about 40% of people in this one business use the password fall 2021 ! Right? Or it was summer in 2020 at that time. Don't do that. Use unique passwords. I was out shopping with my wife and son this weekend and came across a password journal, a book that would encourage you to write down your login information and write down your password and write down the account that it is associated with. Please don't do that. Your IT folks would go insane. It is not helpful. It is not more secure. If you're writing those things down, it's just another weak point for the system. Now, there are password managers out there on the technical side, which can manage your passwords. They can link it to that particular site when you're logging in from a particular device. Those are becoming more and more secure. I myself don't use them, but I do know they are encouraged to be used by some enterprises. So as data privacy has developed, and again, this is something that has changed drastically in the past 20 years, but it has been out there for some time. The first data privacy law in the United States was the Fair Credit Reporting Act, and that was, I believe, in the 70s. And so from the US, that concept has been out there. We have been creeping along with data privacy, but other areas, Europe particularly, have just, it's been exponential how much they have granted to consumers from a data privacy rights standpoint. So these fair information practices are concepts that have developed over the past 40 years. And you will see these play out in the privacy law, comprehensive privacy laws that are being passed throughout the States and in Europe. So the fair information practices you can categorize them in sort of 4 areas. There's the rights of the individual, information controls, information lifecycle, and information management. Now, the rights of the individuals, like I said, these are the 3 common ones that you'll see throughout comprehensive privacy programs and laws. So the first is notice, right? Every time that we are collecting data, we should be providing notice of the information we're collecting. Now, if we are a consumer-facing business, this is significantly important, because if we're collecting data from consumers, that's what regulators and lawmakers are worried about, protecting the individual consumer and their personal information. If we are a business-to-business operation, less of an issue, although it's still coming into play. We'll touch on it a little bit later, but we are seeing customer and supplier contracts that are adding in stringent cybersecurity data privacy provisions. So provide notice of the data being collected, request consent for that collection and or use of that data. So tell them why you're collecting the data, what you're going to use it for, and get their consent for those purposes. Now, from a disclosure of use standpoint, most people understand what they're giving data for. If I'm buying something from Amazon, I know why I'm giving them my name, I know why I'm giving them my address, and I know why I'm giving them my credit card, right? But there are other entities where it's like, well, why does this person need my social security number, right? And so the more that we provide informed notice, they allow the consumer to make an informed decision and consent to the use of that data, the better, at least from a lawmaker standpoint. And then this last one, access. Individuals are more and more being granted access to the data that we hold, right? As businesses, we bring in that data and we use it, and there's times where it just stays there. And there's also times where it's, we dispose of it. But if it's staying there, an individual generally now has the right to request to know, it's called the right to know, what information you have about them. some programs, some privacy frameworks are requiring that they have the right to portability as well. And that if somebody requests to know what they have, and then you tell them, and then they request a copy of it, well, then you are required to give them a copy of the information that you hold, unless there are business reasons not to. Number two, information controls. And this is touching more on the technical side of data privacy and cybersecurity. Data privacy, cybersecurity, I view them as two sides of the same coin. You know, data privacy is more so related to number one here, the rights of the individual, the information that we have about them and how we treat it. Information controls is related to the cybersecurity side, the protections that we use to secure that information, that data, and to secure the integrity of our system. So, you know, from a security standpoint, we're talking about the administrative, technical, and physical controls that we use throughout our business to protect data, whether it's our data or somebody else's, and to protect the integrity of that data. You know, we talked about data breaches and someone coming in and getting access, and the next question is, what do they do with it? You know, do they lock down your system with ransomware and ask you to pay them 10,000 Bitcoin, or do they just sit there and, you know, subtly change things to their benefit? So if you look from a financial sector perspective, you know, if somebody goes in and they're sitting latent in a system and they start changing account numbers or changing wiring information or intercepting wiring information and changing it before it gets to the financial institution, you know, that data is losing its integrity, and that bad actor can start, you know, acting on it. They can insert their wire information, transmit that to the financial institution, and then they get wire proceeds. You know, from a operational practical perspective, I ask my clients to never email me wire instructions, and to not email anybody wire instructions. You know, those sorts of things should be sent securely. A lot of us have Outlook. You know, it's a simple, you know, you send the email securely, and then someone would have to have the correct login information to get that information. There have been instances historically where people are able to intercept emails, and if they're able to see where the wire is going, you know, even though these funds are being transferred electronically, this is an electronic world where they can track that down and divert it to their own account. And so that's one, you know, practical application of information controls. Information lifecycle, and this is something that a lot of people are not intentional about writing down or understanding. So all the data we collect has a life cycle. You know, there's that data, the collection point, there's our storage and use, and then there's ultimately our termination disposal of that data. Use includes disclosure as well. And so from an enterprise perspective, understanding the information lifecycle, understanding where we get our information, you know, is it directly from consumers? Is it from other businesses? How are they getting their information? What does their information include? How sensitive is the information? And then how do we use that information? You know, understanding those aspects of our operations allows us to develop a cybersecurity data privacy plan that's appropriate and satisfies our legal requirements. And then also understanding disclosure of that information. So disclosure can be to a third party, but disclosure can also be internal, right? So I have information that I might share with a coworker to work on a certain project. Well, there's a disclosure there, right? And that can happen in any enterprise, whether there's information that comes in from purchasing, right, that gets sent over to accounting or sent over to operations or, you know, manufacturing. And there is a disclosure there, and understanding where information is going and why is very important. Because there's a concept that we'll touch on a little bit later, but that, you know, we don't need to share every bit of information we receive with every aspect of our business. Essentially, each operational point should only have access to the business they need to satisfy their business purposes. And then the final aspect of information lifecycle is disposing of information when it's no longer useful. If we have used the information that we've collected pursuant to the use that we've notified a consumer of or notified somebody of, and we no longer need it, well, then we should dispose of it, right? Absent some other legal requirement. Because, and I look at it from a risk mitigation standpoint. The more information we have, the higher chance of significant liability exposure in the event of an actual breach, right? And so if we don't need to keep information, then we should be disposing of it. And then the final fair information practice would be information management itself. So this is the monitoring and administering of items 1, 2, and 3 here. We need to have systems in place to know that we're satisfying the structures that we're putting in place to satisfy 1, 2, and 3, right? So we need to monitor the way that we're interacting with individuals as it relates to their information and the information controls that we have. Because as we talked about with California's definition of personal information, it's ever changing. And so there could be, if we are subject to California's law, which we can touch on later as well, many of us might be, our obligations could expand as technology expands, right? As softwares or devices expand, and we need to know that. We need to monitor our system and update it to satisfy our obligations. So I want to give a quick lay of the land, and I say quick, on US privacy law framework. And it's a puzzle. As I said, the United States does not have one comprehensive data privacy framework at the federal level. This is different than Europe. Europe has the GDPR, which is the General Data Protection Regulation, which has been in force since 2018. It has been amended from time to time. Many of us have probably heard of the GDPR. If we have operations in Europe, we might have had to comply with the US EU Privacy Shield, which has since been rejected by European courts last year. But the EU GDPR is a comprehensive privacy law. So it talks about the rights of the individual, and it talks about the enterprise obligations to satisfy and all of these things. The US does not have that. There have been a couple bills introduced in the past few years that have tried to develop a US privacy framework, but there are competing interests at play here. Obviously, you have some very consumer-friendly jurisdictions that are saying that the most important aspect of this is to increase the rights to the individual and give them the ability to control their information. And then you have other side of, hey, this could stifle development, right? If we increase the rights to the individual, if we put a global privacy framework in place, well, then our cost to satisfy regulatory requirements goes up. And whether it's cost in improving the system, whether it's the opportunity cost when we're dealing with countless individuals, requests to know what information we have, all those sorts of things. So that may change. It doesn't look like it's changing anytime soon. So right now, the United States privacy law framework it's a puzzle piece of federal law, state law, contract law, our industry standards, and then our own policies, whether they're internal facing, mostly external facing. And so all of these things work together to create the obligations that your enterprise has to satisfy to have a satisfactory cybersecurity data privacy program. So, as I said, federal law, again, no comprehensive federal law relating to data privacy. However, there are industry-specific federal laws, and many of them we've probably heard of. The financial sector, there's the Gramm-Leach-Bliley Act, the GLBA. This is, as I said, applies to the financial sector. So we're talking banks, credit unions, insurance companies, people of that nature. And then this is the reason why you get a notice every year from your deposit institution saying, hey, here are our privacy practices, or your credit card, or those sorts of things. The health sector, I'm sure we've all heard of HIPAA as amended by HITECH. Again, the reason why you have to sign a disclosure form every time you go to the doctor, it seems. The educational sector has the Family Educational Rights and Privacy Act, or FERPA. This applies to educational institutions that receive federal funding. Online activities are governed by a myriad of laws. The most probably, it's been around for the longest, I believe, would be Controlling the Assault on Non-Solicited Pornography Marketing Act, or CAN spam. So this applies to the types of information that we can put on the website without having to get consent from the user of the website, and it protects minors from accessing, obviously, information they should not. Now, these types of laws have two aspects to them. They have particularly the GLBA and HIPAA have both data security requirements and then individual rights requirements, right? So they're satisfying both sides of that coin I talked about, because these are comprehensive in that industry. So health sector applies to covered entities, right? Healthcare providers, insurance companies, and information related to that. There is a privacy law, which is the way we, the healthcare provider, treats the information of the patient. And then there's the security rule, privacy rule, security rule. And the security rule is those technical requirements of how it's protected. And the GLBA has similar. Now, these two have similar elements, which you'll also see throughout comprehensive privacy laws. They require notice, as we talked on. They require a written internal privacy policy or an internal privacy statement that provides for appropriate safeguards. And again, you'll hear it a number of times, but appropriate safeguards being commercially reasonable, administrative, technical, and physical safeguards. That's how we create a satisfactory cybersecurity program. And then they have a legal requirement for testing and training of personnel. And again, this is something that I'll hit on a couple times as well. The more we test, the more we train and make our personnel aware of this issue, the better it looks that we're treating cybersecurity as a serious issue. So, it tells a regulator, it tells an enforcement body that we're doing what we can to address these things. State laws come in many different shapes and sizes. So I'll start on the right first here. Every single jurisdiction has a breach notification law. So if you are subject to a breach and it qualifies under that law, then you have to notify the individuals affected. So Indiana has the Indiana Disclosure of Security Breach law, and as I said, you must notify the individual without unreasonable delay if a company knows or should know that the breach could cause identity theft, right? So there's a couple bars there. One, the unreasonable delay. You can, as noted below, you could push the notification as necessary to restore your system, remediate that data, or conduct a reasonable investigation. You can't push it 2 months, right? But you can push it as you need to really go through those steps. And then the other hurdle of the requirement is that you know or should know the breach could cause identity theft. This relates back to the definition that Indiana uses for personal information, right? Identifier plus something else. So if somebody just gets a last name, it's not likely that that could lead to identity theft, because that's directory information. It's information somebody could find in a phone book, if they still have a phone book. But the identifier plus information, plus the account number, plus the login information, that's where that could cause identity theft. And at that point in time, our obligation to disclose the breach is triggered. Again, one other exception is if the information is encrypted and the key has not been compromised, right? So if we're encrypting our information and there's a breach, someone gets all that information, but it's encrypted and they don't have access to the encryption key, well, then that's not a breach. They can't meaningfully use that information to cause identity theft. All right, so every jurisdiction has something along these lines. Some jurisdictions are more permissive than others. Some, if there is a breach and it affects X number of individuals, regardless of how the data is classified or protected, you have to disclose. Keep in mind, a lot of jurisdictions have, if a data breach impacts a significant number of individuals, which that number can range, 100, 500,000, then you have to disclose via media. So you might have to put a disclosure in the news or newspaper of general circulation, things along those lines. But that's breach notification. That's only if we get to that point. Now, state laws address the other side, the data privacy and cybersecurity side as well. So from an enforcement perspective, every state attorney general has the opportunity to enforce unfair and deceptive trade practices. We'll touch on that in a little more detail here at the end of this segment, but again, they can bring an enforcement action if they view your actions as unfair and deceptive. Now, states have taken different approaches to addressing data privacy and cybersecurity. There's been the comprehensive privacy law approach, or more more so approaches directed at the cybersecurity framework itself. So as we said, California has the highest bar for a comprehensive privacy law in the United States. That started with the CCPA, which went into effect, I believe, January 1 of this year. The CCPA has already been amended and a new version will replace it starting January 1 of 2023. But from a general perspective, this privacy law captures all those fair information privacy practices that we talked about earlier. So it talks about the rights of the individual. It talks about the information control, information management and information lifecycle. From a rights of individual standpoint, it grants the individual significant rights. The right to know what information you have, the right to access that information, data portability, and most concerning at times is the private right of action to the individual consumer. So a consumer, if they believe and can show that you have breached the CCPA, they can bring a private right of action in a court of law. And the CCPA has statutory damages for each breach of it. And so that can quickly build. So if you tripped up, once in one spot and unknowingly, and certainly not in a bad faith manner, that can quickly accumulate it if it's affected a number of individuals. Now, the CCPA applies if you have information of California residents or individuals or households exceeding, I want to say 50,000, but I don't know right now off the top of my head. But again, it is not any California individual. It's a certain threshold amount. However, if you have significant operations, significant sales, relationships in California, it certainly is a threshold that can be reached pretty quickly. So it's something to keep in mind. Virginia has passed a similar comprehensive privacy law. It's probably the most similar to California's, and that will go into effect January 1 of 2023. Ohio has introduced a bill that is a comprehensive privacy law, but one significant difference is Ohio is not providing a private right of action at this time to Ohio residents to bring a claim for a violation of their privacy law. So there's going to be a spectrum, which is sometimes difficult to manage and administer. Is you need to know what your requirements are in each jurisdiction, similar to if you employ individuals in different states. What are my employment requirements? And so, in each jurisdiction, there may be a different comprehensive privacy law that we need to satisfy. Indiana does not have one introduced right now. Michigan does not have a bill introduced right now. Illinois, I do not believe, has a bill introduced right now. But just last year, there were 20 different states that introduced new comprehensive privacy laws, spanning the spectrum. Well, some of them failed. I think there are 5 currently sitting out there. But from a passage standpoint, California's passed, Virginia's passed, and Colorado also has passed a comprehensive privacy law. Illinois, interestingly, has it's a more specific comprehensive privacy law, more specific privacy law, I should say. It's the Biometric Information Privacy Act. Interestingly, this was passed back in 2008. So it's been in force for a long time, but it's now getting more traction and more enforcement. And it deals with what it's suggesting, biological information. So if it's coming into play a lot with mobile apps or smartwatches, things of that nature, video monitoring. But if you are collecting data about someone's biology, fingerprints, eye scans, all these sorts of different things, heart rate, all the things that come like in all these health apps, things of that nature, that would fall under the Illinois BIPA. And that has had significant enforcement over the past 2 years. There have been significant awards. So if we are in the consumer realm where we are dealing with biometric information, that's certainly something to keep in mind. So those are the comprehensive privacy laws dealing with data privacy and as it relates mostly to the consumer. New York has gone a different route, and they've gone more so with a cybersecurity framework. And I should say they have introduced a comprehensive privacy law into legislature, but it has not been passed. So right now they are operating under this cybersecurity framework, which is the SHIELD Act. So the New York Stop Hacks and Improve Electronic Data Security, the SHIELD Act. And this is broader in the sense that it applies to any person or business with private information of a New York resident, one, We're not talking about thousands, tens of thousands. We're talking about if you have information about a New York resident, you need to comply with SHIELD. And that every entity with that information shall develop and maintain reasonable safeguards to protect such information. Again, reasonable safeguards. What does that mean? Thankfully, New York has provided more direction on what reasonable safeguards are. And I'll actually walk through those here later, because I think that jurisdiction has told us in businesses what they need to do to satisfy these requirements. So I like to point to that direction as, what clients should do. And, here's what's been viewed as reasonable in this capacity and how it can apply. Indiana does not have a framework. It does not have a comprehensive privacy law, but it does have a line in its Indiana Disclosure of Security Breach that says businesses must maintain reasonable procedures to safeguard personal information. It is one sentence long, but it's there. The Indiana Attorney General could enforce it. Have not seen a lot of enforcement on that issue in the past few years, but we're not sure if that will increase or not over time. But that's certainly something to keep in mind. And then contract. So this is another way to create, obligations on your enterprise for how it must maintain data. Contracting parties are free to negotiate their information security frameworks. I'm seeing that often on a, almost on a daily basis of customers or suppliers inserting data privacy protections or provisions into their agreements. Those provisions can be, you must have your own system, you must comply with our system, you must comply with this framework. But there's just different ways that that's coming into play. Now, this often depends on the type of relationship, the scope of the relationship, type of information, and the sophistication of the parties involved. If we're talking about software licenses, whether it is an individual software application that we're putting into our system, establishing on our network and using, or software as a service where we're using somebody else's software, there's certainly provisions in there, or licensing out our own software, I should say too. There's provisions in there that have heightened data security requirements because we're dealing in the data world all the time. And so if I'm contracting with a software provider, I need to know that they're maintaining my information at a high level. And so you'll see those in there. Federal contractors generally have these data privacy cybersecurity requirements, but now there's a heightened focus on that. Particularly with SolarWinds and some of the prior hacks from earlier this year. And so there was an executive order related to, shoring up the supply chain as it relates to cybersecurity. And just this week or last week, I should say, the Department of Justice said that they are going to, focus on enforcement when it comes to federal contractors. So the commitments a federal contractor makes in its contracts to cybersecurity and data privacy, the DOJ says that they're going to come down on that. If you violate it, if you've misrepresented it and you don't comply, it's just a heightened level of focus from the federal perspective. Now, I do have a couple contractual provisions that I've seen recently. These are provisions that I have seen in actual contracts and that are generally used on a daily basis. So the first one is the service provider relationship. And it requires that a service provider shall implement and maintain a written information security program, including appropriate policies, procedures, and risk assessments that are reviewed at least annually. Without limiting service providers' obligations, service providers shall implement administrative, physical, and technical safeguards to protect personal information that are no less rigorous than accepted industry practices. So there's a couple key items there that you'll see throughout these. They come into comprehensive privacy laws and also contractual provisions. One, the requirement for a written information security program. Laws are requiring businesses to actually write this down, to sit down, to think about, to be intentional about our information security, our data privacy programs, and to have a written policy in place that we can point to that says, here's how we treat things, here's why, here's what happens if there's an issue. The other requirement that we're seeing across a lot of different, whether it's federal law or state law, is that these plans are reviewed at least annually, right? So that first sentence there is essentially saying you are going to comply with your legal requirements. That's what that's getting at. Now, the second sentence goes a little beyond that. Now, It says the service provider shall implement administrative, physical, and technical safeguards. We talked about that, you know, that's deemed to be the reasonableness standard, right? And that's what we're supposed to do. But the last clause, that are no less rigorous than accepted industry practices, is a little more nebulous. What does that mean? It depends on what industry you're in. It depends on, and frankly, what has happened to that industry over the past year. So, I mean, if we look at supply chain issues this past year, the SolarWinds attack or things along those lines, there are now industries that are drastically ratcheting up the requirements for cybersecurity protections. But there are industries out there that aren't at that level yet, right? So what does that mean in this context? And that's something that we need to know. And so this provision was offered by, I believe, this client's one of their more significant customers. And so this is a customer requiring that you satisfy these provisions. And so obviously, you know, if we need to, this isn't a consumer facing business, but if our customers are requiring it, then, you know, it's something that we end up having to bring into our practice. Now, this bottom one is pretty similar. You know, you need to have a written security policy, commercially reasonable administrative, technical, and physical measures consistent with industry standards. But if you go down to the last sentence, provider agrees that it will comply with customers' information security and privacy requirements. So you have to have your own internal policy. And I'm fine with that. I counsel all my clients to have one. I counsel my clients to have commercially reasonable administrative, technical, and physical measures, you know, to protect private information. You know, we'll match to industry standard. But when we have to start complying with customers' information security practice and privacy requirements, that could be an issue. Have they provided us documentation showing what those are? Do they have requirements in their industry that go well beyond our requirements? Have their practices changed? Do they change? You know, again, we're supposed to be reviewing these annually. Are the customers' practices changing annually? Then we have to change our practices annually. You know, a sentence like that, if we're satisfying the preceding language, which is basically our legal requirement, then that should be enough. But if a customer is then trying to force their policy onto you, then it becomes a question of, you know, what additional cost is that imposing? Is that monetary cost, you know, opportunity cost? And it's something that we need to look into and just confirm that we can in fact comply with it. So we talked about industry standards a little bit on the prior slide, but many industries provide guidance on generally accepted best practices. The most visible would be the payment card industry. And so the PCI DSS, every time there's a credit transaction, this comes into play. It has certain requirements for a credit card processor, but importantly, there's actual penalties from the industry association. So the Payment Card Association can fine, they can say loss of privileges, so they can't use the payment card system, and they can have direct damages. Now, all this is to say that industries, if you sign up for an industry organization, they might actually have some enforcement remedies against you. They could fine you. They could, cause you to lose certain privileges that might impact your business. So something else to keep in mind. And then finally, external policies. So as I said earlier, the FTC, they're empowered to enforce unfair and deceptive trade practices. Now, this comes into play every time that we have our own external facing policy. So if we're telling somebody, whether it's a consumer or another business, that this is how we treat your private information, right? That creates a contract between you and that outside party of what your trade practice is going to be. And so if you're not complying with that policy, well, that's deceptive. You know, we've told this party that we do X, Y, and Z, but we only do X. Well, then we're deceiving them in relation to Y and Z. And then unfair trade. So the biggest example of that, I think, is Snapchat. A few years ago, Snapchat had a huge claim against them because it held itself out as, hey, these images, these messages are sent, they go away forever. Turns out Snapchat records everything and they maintained it all. And so that was viewed to be a deceptive trade practice. Unfair trade practices, not deceptive, but our actions aren't really commercially reasonable. You know, we should be doing more. We should have been doing this and not just that baseline that we were offering. I'm going to go through this because we'll talk on policies a little bit more. So from your perspective, some key considerations. Know your industry. You know what data is in your industry, what data you are receiving. Know where your customers are located. If you can, know where their customers are located. because that'll tell you what kind of data you're getting and what your obligations are in relation to that data. Understand your contractual obligations. What have you committed to in a contract? If you're a federal contractor, fly spec it, understand what you need to do, confirm your practices match your policies, and develop a commercially reasonable information security policy. So understand the information you possess, understand your capabilities. Know your digital environment. Understand that your digital infrastructure is complex. It's not just computers anymore. It's all these different devices. It's our different storage, whether that's on the cloud, whether that's on physical servers. It's networks, whether they're internal or external, our vendors and our personnel. So let's get to actually developing your own reasonable security practices. Again, we've talked about it, reasonable administrative, technical, and physical safeguards. That will generally keep in mind or take into account the sophistication and complexity of the business itself, right? So again, small business not held to the same standard as Google or Facebook, but we still need to do commercially reasonable things to protect our information. So from my perspective, a couple of those items are data mapping. As we talked about, know that information lifecycle, know where that information is coming, know how we store it, know how we use it, know how we dispose of it, know where it goes internally, right? So if we map out where the data is, we know where the vulnerabilities are, at least most of them, and then we can try to shore those up. Asset management. Know what assets have access to your networks, right? So like I said, hey, employer provided laptop certainly has access, but my cell phone also has my work email on it. So that has access to our network, has access to our data, right? And understanding those sorts of things, what devices are accessing data, it allows you to protect your information. Responsibility and accountability. This goes along with training of your personnel. You know, I think a very important thing for every enterprise is to have, you know, one person or one department who's responsible for their information security program, because everyone needs to know where to go. And it's not just up the management chain, because that might take too long. This is something that's always moving. There needs to be an information security director, manager, for lack of a better term. And it doesn't have to be a new role, but people need to have direction on where to go. Security by design is a concept that data security is not an afterthought. It's not, hey, I'm going to buy this software, put it on, patched it up, we're good to go. It's being intentional and thoughtful about the process and understanding, you know, where our vulnerabilities are, what data we have, and how we can protect it. And lastly, the safeguards, physical, administrative, and technical. So certain aspects of a reasonable security practice, and that includes an internal privacy policy. So that written information privacy program that tells what data we have, how we protect it, what do we do if something goes wrong. A consumer facing or user facing website privacy policy, telling folks, here's the data we take, here's the data we collect, here's how we use it. Also include terms of use in there, you know, telling users how and when they can use your website and in what manner. Now, these things should be reviewed again on an annual basis. That is the bar for being reasonable in a lot of jurisdictions. You can have these things, but if they're dated, they'll be deemed unreasonable. So they should be reviewed. And that doesn't mean they have to be changed. It means we have to look at them and make sure they match what our requirements are. Personnel training, again, train personnel on these issues, make them aware of them, and then testing. You know, you can do penetration testing where you bring in a third party and they try to hack into your system. You can do table exercises where you discuss what would we do in the event of breach, whether it's a small breach, a big breach, what information's accessed, and then how do we respond? These sorts of things show that you're thinking about this issue and you're taking steps to address it. Great. So these next 3 slides are going to touch on technical, physical, and administrative safeguards, and they're going to be examples that are provided mainly through the New York Shield Act. Because again, like I said, that seems to be the most developed and mature cybersecurity framework with the most articulated direction on, hey, here's what you should do. So from a technical standpoint, and again, yeah, you know, technical things they can get out there, but if you just look at the general concept, it's easy to work through a checklist. So review your network and software design. Make sure it makes sense to your system. Assess the risk associated with the current design and adjust as necessary. Not, hey, there's the newest, shiniest cybersecurity software. Let's buy that. That's going to solve all of our problems. I'm telling you that's generally not the case. You know, if that software solves one backdoor, it probably opened a different one. And so we want to go with security by design and be intentional about it. Review your data map, assess the risk in the collection, the processing, transmission, and life cycle of the data, right? Understand how we're sharing data internally. To the next point, encryption of data at rest and in transit. If we've collected data, if we have information on our system, is it encrypted when it's just sitting there? Or if anybody had access, would they be able to use that data? Generally, using Outlook, most of our data is being encrypted in transit, email exchange and that sort of thing. But understanding where we're putting data and how it's moving can really decide, what type of technical safeguards we have in place or need. Control administrative privileges. So there is a concept out there called the principle of least privilege. And what that means is, essentially an employee only needs the information they need, right, to do their job. And they only need the access they need to do their job. They don't need to have full administrator access if they're just in one department, right? And this could be in any sort of operation, but we don't need to grant privileges to everyone across the board. We actually need to grant them the least amount of privileges they need to do to satisfy their job. And to do that, that creates a more secure system because there's less vulnerabilities for a bad actor to come in and get credentials from somebody who has managerial privileges, but is not in that role. Related to that is we need to have a system that can detect and respond to breaches, to monitor breaches by logging and that sort of thing. So we know who's accessing what and when. And then this next point, low-hanging fruit for a reasonable cybersecurity framework is multi-factor authentication. So if you have not enabled it, do so. It's really not as big as a headache as some people make it out to be. All it's saying is you'll log in with your credentials, then that system will send you a verification code, and then you plug it in. It's just one more level into logging. It's not foolproof, but it does, it adds an extra layer of protection, and it has been a factor in saying, this is a reasonable framework. And last, regularly test and monitor your systems with penetration testing or table exercises, as we discussed. Administrative safeguards. As I mentioned earlier, identify a coordinator responsible for administrating your program. One person, one department. Train your personnel in that program. Record keeping, document control, revision control. So if we're reviewing these things annually, note that. Say, hey, we last reviewed this in October of 2021. This is that revision, and make sure you have that control so that you can demonstrate and document the process of your program, how it has changed and why. Do a risk audit on an annual and ongoing basis. This last one's very important. Vet your service providers to ensure that they have adequate safeguards, right? We can talk about our internal safeguards as much as we can, and we can put in a reasonable cybersecurity standard, right? With those administrative, technical, and physical safeguards. But if we grant access to somebody into our network who doesn't have those safeguards in place, well, all that work that we just put in to shore up our system goes out the window. Because if someone can access them, they can access us, and then they can just move throughout our network and wreak some havoc there. So this includes our cloud assets, our hard assets, and our IT services. These are the really sensitive areas where you want to make sure these service providers are matching your standards. And so that comes in the vetting process and in the contract negotiation. Last, physical safeguards, review your assets, manage those assets through loss detection, keep track of them. Ex-employees or an employee that loses a laptop or a cell phone, those sort of things it's an open vulnerability if you never recover those things. I'll skip over to protect against unauthorized access, dispose of information, train your personnel, again, to recognize what's abnormal about their system. I email our IT guy once a month of, hey, this thing looks weird, and then he tells me everything's fine. But, if you are uncomfortable, you should feel empowered to reach out to somebody who knows what's going on. And the last one, in all caps, change your default passwords. As we said, make sure you use real strong passwords and don't get assets, IT assets, and just leave the default passwords in place. Because it turns out those default passwords aren't secure. Some of them are universal. And if you aren't changing them, someone will always have access to your system. Great. So best practices from an organizational standpoint. Keeping in mind the technical, administrative, and physical safeguards. Take an intentional approach to address your security program. Identify that responsible coordinator who understands that they are empowered to develop a program and address it as they can. Revisit it each year. Encourage enterprise-wide buy-in. Again, humans are humans. They will be a weak point in this. We are getting countless phishing emails. I think in the 6-month period from when work remote really became prevalent last year, phishing campaigns increased something like 400%. That has gone up another 1,000% or so. The barrier to entry to become a hacker, to send out just blast emails, is very low. And so if they're nation state sponsor, or even just somebody in a basement somewhere, right? They can do this, and all they need to do is send out tens of thousands of emails and get one person, 2 people to respond, right? And then it's worth it. It's worth their time. Principle of least privilege. Again, do not grant universal privileges and administrative privileges across your organization because it's not necessary. Only let people have access to the things they need to have access to. And consider contracting for third-party cybersecurity risk assessments. There are firms out there that will come in, they will look at your system, they can do a pen test, they might just do an audit, but they'll tell you where your weaknesses are and things that you can adjust. Some of these are pretty cost effective in that they will tell you, hey, if you click on, you clear out these 3 things, you're going to have a pretty strong system. So that's something to keep in mind. There's local service providers or even national brands who can do these sorts of things. From an operational perspective, there's some easy low-hanging fruit. You see multi-factor authentication there. You see training, changing passwords, encouraging strong and unique passwords, and training on the ability to recognize a phishing email, and enforcement of the program. But that first bullet is something that a lot of enterprises don't think about, just because, we look at our information as our business information. We need this information to do our work, but we don't look at it as different classifications of information. And so when you're doing that data audit, that data mapping, and understanding what information you have, keep in mind there's different levels of information. There is non-confidential information, directory information, right? Things you can find in a phone book. Then there's that next level of information that should have a higher treatment, more sensitive treatment. And then there's the highly confidential information. And those are the general 3 tiers that you'll see across privacy programs. And it shows that as an organization, you're intentional about your program, because that, hey, someone's first name does not deserve the same level, does not require the same level of protection as someone's social security number and bank account number and more information, right? And there's a spectrum that you can satisfy your obligations to each level without having to take on the administrative costs of treating everything as highly confidential. All right, so there are a few resources that I wanted to point you to that can help you in this process. One is, well, it's not the Center for Information Security. It is the Center for Information Security, the CIS. And they put out their 18, it used to be 20, now it's 18 critical security controls. And again, I put them here for you. They're very similar to everything we've touched on throughout this presentation, inventory enterprise assets, inventory software assets, all those sorts of things. They're almost universal to developing a privacy protection program. And the Center for Information Security has certain tools that you can use and you can adapt to your enterprise. But again, this is the starting point. If you go through and you're thinking about these 18 things, right, you're showing that you're intentional about data privacy and that you're intentional about how you're treating the consumer's data or your customer's data, but also how you're protecting it on your end from an operational standpoint. And again, so the CIS security controls go through both data privacy issues and then also a cybersecurity framework. Some additional resources are the National Institute of Standard and Technology, NIST, which is the NIST, which has been getting a little more play in the past few years, I think, as headlines grow. But this is a governmental organization, which I think is a joint effort amongst a couple of agencies. But they can provide you, similar to the CIS controls, a framework that helps you develop a program. And so they actually have on that website, they actually have form Excel files or PDF files that can help walk you through this process of how to develop a program, whether it's a cybersecurity framework or privacy framework. It depends on how detailed you want to get, what your industry requires. I'll say a lot of industries, when you talk about industry standards, they are pointing back to NIST and IST. They are pointing back to the CIS controls and saying, hey, if you satisfy this, you're going to satisfy our industry standards. So it's a good starting point. You're seeing it in contracts as well that say, hey, it's your levels are at least as stringent as X, Y, and Z. And so, it can give you direction there. Now, it's not a detailed that says, hey, this is the program you need. This is the safeguard you need. It's the thought process that we've been discussing of, going through your operations and where your vulnerabilities are, how to address them. And then it really shows you, how all these things are intertwined. And I think that's the most beneficial thing about the NIST program is that it shows how each aspect relates to the other. And then CISA, the Cybersecurity Infrastructure Security Agency. So a federal agency, which they provide a lot of tools related to business in addressing cybersecurity issues, recognizing that some of these things can be costly. And there's a world right now where there's always a new cybersecurity software. There's always the new tool to fix your system and to secure your system. And again, that's not the answer, because software development is always ongoing, right? And there will always be that next thing. But if the foundation, if your own program is not strong and sufficient, then even just adding on that software is not enough. So some of the tools that CISA provides is they have an assessment tool. So it's a cybersecurity evaluation tool, and it works right. Mostly, we're looking more so at a small business standpoint, but they have incident response as well. So tools to tell you how to respond if there was a data breach. Governance, so internal directions on what your organization should do and how they should administer the program. Detection and prevention. And again, that last one, education, it's a big one. The more you're training personnel, the more they are aware of what's out there and what the issues are, the more likely they are to recognize where a problem is, and then you avoid it before it becomes an issue. Before they click on that phishing email link, they understand, hey, this is weird, this is abnormal, doesn't look like a real email. I'm gonna take a step back. So the educational perspective, again, vitally important. And now we have time for questions.
Right, I don't see any questions in the Q&A. So if you do have questions, please go ahead and put those in. And one thing you had mentioned, Justin, was regularly changing passwords. Is there like an industry standard of how often maybe that's recommended?
It's not just because I think it depends on the industry. It depends what market you're looking at, what your stomach is for risk. But I think we're set at 45 to 60 days here internally. I know I try to change mine more often than that. I have seen organizations that say you must change it every 30 days. I've seen shorter time periods. Some organizations can actually give password encryption tools so that there's different authentication levels. But yeah, there's no simple industry standard for how often to change the password.
Okay, all right. And you, did you say, would you recommend not taking those suggested passwords that come up, or was that something else? Because they seem to have like a lot of digits and things and that seem good.
That's a great question, Lisa. Yeah, I don't use them myself, but I don't think they're a bad practice. I actually do think that they're certainly better than using fall 2021 exclamation point, right? And so I do think they're an offshoot of these password management softwares, which are actually pretty well secured. So yeah, I think you can use those and be more comfortable than certainly if your password is password, that's the problem. But these strong passwords, they can be helpful.
Okay, all right. And, I just think, as you were talking about one of these third party, risk assessments, people may say, I even was in a presentation yesterday where they say only 1% of nonprofit budgets go to technology. So much of what they get for funding, requires them to put that money into specific programs. So they're not, maybe, having, obviously IT departments and so forth. So you would probably say it's definitely worth the money to do an assessment, to get an outside vendor before you have to pay like a large litigation.
Well,
amount.
yeah, I mean, that's always that cost benefit analysis, right? Is it worth the 5,000, 10,000 upfront to avoid $200,000 road? But I would say for organizations who do not have that budget level or authority to use their funds in that manner, that CISA, the Center for Information Security Agency does have those tools, can be helpful for that sort of organization. To walk through what an assessment would look like, and to walk through their system, which will provide it's not that third party vendor level, but it certainly is more direction than, hey, we think we're good, right?
And from what I was hearing from you, as long as you have on your end, security, and you ask your vendor, that this is what we require, then they would be the one who would be liable if there is a breach.
So there's always that shift of risk, right? We have to allocate risk appropriately. So if it's information that we've secured and there's a world where that's still our risk. So if you play it through, if say our organization took in an individual's information and there was a breach, and that individual had the authority to bring an action, or even the FTC brought an action against us, we would say, hey, that breach wasn't our fault, it was service providers. And then we would have to show that, right? And contractually, we could allocate that risk to them. But it doesn't stop us from being involved in a dispute, but we certainly can say, no, it's their responsibility. And when you're working through your service agreement, you can allocate the damage responsibility to them as well, and say, hey, if there is a claim related to your actions, you will indemnify us and pay us for those costs and damages.
Mm-hmm. And obviously, with huge corporations, there have been, gigantic, amounts, of litigation, because they have, millions of customers. Have you yourself been involved in any kind of litigation? Like what kinds of amounts, would somebody be liable for, a business?
Yeah. So one, I am not a litigator. I am a business attorney. If I'm in a courtroom, somebody else in this building would be in the courtroom. We've handled data breaches. We've handled ransomware responses as well. And so from a data breach standpoint, have not seen high dollar amounts in our area or with our clientele. For the most part, there have been some claims. Internationally is where you're seeing a lot of bigger numbers. So under the GDPR, it's a much more active jurisdiction as it relates to data privacy litigation. And so, I mean, Amazon just got hit last week with a significant fine. But in Indiana itself, we're really not seeing a lot of that yet. California has not, and again, that's the highest bar in the US, has not seen a lot of high damages cases. I would expect that to change here moving forward, just because the enforcement is going to change a little bit there as well. Last year was the COVID year, and it was different from a regulatory standpoint. I do think now that CCPA has been enforced for, we're going on 2 years now, that there will be an uptick in enforcement, and you will probably see some bigger damage awards over in California.
All right. Well, thanks, Justin. I know, as soon as, things change, there's always some criminal out there who's ready to take advantage of the situation. So it's amazing the amount of, different scams and things that you were going through. So is there anything else you'd like to say in closing?
Well, I would just like to touch, it looks like we have a comment from Dean Wilson, and my understanding is that Microsoft has changed its stance on regular changing passwords because people did generally change They did generally just change their passwords by a digit or a character or so. I would
Adding
not.
the exclamation point or the number
Yes.
one.
Yeah. Exclamation point number two. Yeah. Again, yeah. Got to go with unique passwords. Don't use passwords across different logins. I guess they don't require mandatory changing, but you certainly should do so on a regular basis. You have a great point. Yeah. Do not just shift your password by a character. The last thing I'd say is, I provided those resources in there. Happy to discuss more if anyone has any more particularized questions. My contact information is out there. So from a data security standpoint, we're able to, help your organization from start to finish, and we'll be happy to discuss whatever your compliance obligations are. But I again appreciate everyone's time, and thanks for joining us this morning.
All right. Thank you for that informative presentation. I know I learned a lot, and I hope those of you who are out there remotely too. So if you didn't get a chance to ask your question, don't worry, Barrett McNagny is going to respond to any follow-up email to everyone who registered today. We'll send out the video to everyone who registered, so be on the lookout for that. If you would like to view previous Business Weekly webinars, submit a topic you'd like us to cover, or find out how you can become one of our presenters, visit us at www.kpceventbuzz.com/webinars. www.kpceventbuzz.com/webinars. The webinars are free for Business Weekly subscribers. Non-subscribers will pay a small fee. Our next webinar, HR Law, will also be hosted by Barrett McNagny. So I want to thank Justin again, and have a great day, everyone. Thank you.